Criminal Session Case number 132 of 2026, Uganda versus Christopher Okello Onyum.
We are going to have the lawyers submit to the court. They are summarizing their evidence and the law to the court, and so we may not need to interpret in the Luganda language.
Kigenda okukolebwa essaawa zino bapuliida b'enjuyi zombi bagenda kuwumbawumba obujulizi obwaleetebwa nga babikwanaganya n'amateeka era tuyinza obutavuunula ekinaba kigenda mu maaso ekyeza empumbawumba eziweebwayo sayidi zombi.
Do you have an indication of how much time you will need? Do you have an indication?
My Lord, I don't have the indication how much time I need.
Really?
Yes, my Lord.
Okay, we shall. Let's take it now.
Okay. My Lord, permit me to begin with the brief facts of this case. My Lord, it is alleged that on the 2nd day April 2026, the accused before you participated in the murder of the infants at Gava Childhood Learning Center, much in the district, much in the division, Kampala district. It further alleges that he was arrested at the scene of crime. Police swung in motion, came at the scene, took over inquiries, and he was taken to Kabalagala police station. Inquiries were commenced, file sanctioned by an officer from DPP's office, Machindye. He was committed subsequently after inquiries, and this trial commenced on the 13th day of April 2026. My Lord, our submission, it is trite and common law that it is the prosecution to prove its case. Therefore, the burden of proof is on the prosecution to prove the case against the arraigned person in court. My Lord, Article 28, 3A states, an accused person is innocent until proved guilty or until he pleads guilty. The accused before you, my Lord, he entered a PNG before you. Hence, in the bid, the prosecution to prove its case beyond reasonable doubt, relied on 18 witnesses who were brought in court and thoroughly examined. The defense brought 3 witnesses. My Lord, throughout the evidence of the prosecution plus defense, evidence came to this court that the accused before you had issues of mental challenges.
Would you kindly refer me to the witnesses that say that?
My Lord, I'm coming there. However, allow me quote the section, then I come to the witnesses.
Please, go ahead.
Much obliged, my Lord. My Lord, Section 11 of the Penal Code Act states, I quote in verbatim, a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he or she is through any disease affecting his or her mind, incapable of understanding what is doing or knowing what he or she ought not to do the act or the omission, but a person may criminally be responsible for an act or omission although his or her mind is affected by the disease of mind, if the disease does not in fact produce upon him mind one or other of the effects mentioned in the section. Therefore, my Lord, the conduct of the accused person and the mind must work together for one to be criminally responsible for his or her acts. My Lord, it's on record that between the year 2016-2025, from PF 24, the accused had episodes of mental illness. And he had things like illusions. He tried to commit suicide. On the same PF 24, that has ever killed another person related to him or participated in that death. His younger brother or his big brother, DW2, came to court and said he was ever in a mental facility, that's Utabika Hospital. My Lord, the doctor at IHK examined him as of 31st December 2025 and pronounced him normal. And many questions were put to him, and some of the questions he alluded to, that a person with mental episodes, they can occur at any time.
Can you repeat that? I haven't understood it.
That a person with mental episodes, mental illness episodes, they can occur at any time.
First finish the sentence. Some questions were put to him.
Many questions were put to him. Among others, the answer was that a person with mental illness or challenge.
That is during cross-examination.
Yes, my Lord. Those challenges can happen at any time in his life. My Lord, upon arrest of the accused person, on the 2nd day, April 2026, he was taken to a police surgeon on the 7th day, April 2026. And the first witness alluded the fact that at the time, at the scene of crime, he was breathing heavily.
The first witness?
No. PW6.
Maybe, Counsel, you may need to advise me whether you are conceding to the fact that he was at the scene.
My
Are you
Lord,
conceding to that?
I'm not yet conceding.
Okay. PW6 testified that he was breathing heavily.
Yes. And the same PW6 has no expertise to find out whether he had any health challenge. My Lord, further evidence came to court from the accused himself that he was distressed that he had started living on the street, though adult, but as a street kid. Whereas it came to this court that he had a rental house in Chanja. It calls for investigations, my lord, that if a person abandons his home and goes to the street, there must be a challenge. My lord, further evidence came at the time of his arrest. He had painkillers, including diclofenac, and they were exhibited. When we cross-examined one of the witnesses, he said that at the time of arrest, he had those painkillers, and that the previous day was in great pain. The information from the suspect. My lord, evidence came in court that the accused person entered into various transactions, including a rental agreement, car rental, and he was also driving. My lord, PW 11, at page 31, at page 131, my lord.
131 of what?
Of the proceedings.
PW 11 is who?
My lord, my sister is checking. He stated, a person with a mental challenge can transact, can drive, can even plan how to commit a crime. That is Dr. Norman Emmanuel.
Wamanya.
Okay, my lord, this is a transcribed because they must have
in Wamanya.
much of life. My lord, did WU2 still confirmed he was in Utarika?
Did he say a person with a or mental illness can do that? Or he said during the time when he's normal, even if he has episodes?
My lord, thank you. I pray you right during the time when those episodes he can do business as a normal person.
I've noted that you say that DW2 also confirmed that he was in Kabika.
Yes, my Lord. Okay. My Lord, between 1st January 2026 and 7th April 2026, there is no medical opinion that came to court that this person, medical opinion.
1st January and 7th April.
2026.
The first examination to the other examination on PF24.
Yes. There is no medical expert who came to court that during that period he was normal. My Lord, it's on court record that in February 2026, he applied for citizenship of Uganda. My Lord, during the cross-examination of the doctor from IHK, did PW12, a question was put to him and he answered that it is possible that the Ministry of Internal Affairs might have denied him citizenship because of mental illness. And that his report
record. Just read it out to me. If I recall, I think you put up is not common, or whether it is not a possibility that some people are denied citizenship. And for specifically that one, I don't remember it.
My Lord,
help me read the record, please.
My Lord, I pray that you write the record will be before you to scrutinize this.
Oh, I don't want to write things that didn't happen here because that would be misleading.
Okay, my Lord, let me read my question verbatim.
Okay.
Will I be right according to your experience with the people who are applying for citizenship in Uganda, standing for that report? One of the reasons is that those with mental challenges are not granted citizenship. My Lord, this is the answer. It is possibly. It is a possibility, my Lord.
Exactly. That is exactly what happened.
Yes.
Not what you're saying.
My Lord.
Because what you're saying is that he could have been denied citizenship as a result of mental illness. But that's not what he said. You remember? That's not what he said.
My Lord, I pray you write what I've written, what I've read to you.
Okay, I want us to be professional enough so that we bring to the court what transpired in court.
My Lord, if you are to remember, I was not reading on the record. I was quoting for you.
No, but you are quoting for me something that is not accurate. That is my concern.
My Lord, let us continue.
The accurate one is that he said it is possible that somebody could have been denied. Not that this particular person had been denied because of mental illness.
Kindly, my Lord, write what I'm reading.
It is okay.
Much obliged, my lord. This is what he answered. It is a possibility, my lord.
Okay. Let's proceed, please.
My lord, if it is so, the question is, nobody here has knowledge as to whether on the 2nd day April 2026 he was normal or not. My lord, according to the law or authorities, if there is any guesswork and contradiction, those contradictions are resolved in the favor of the accused person.
There is guesswork.
Guesswork or contradiction. Now, my lord, this court is left to guesswork as to his mental status on the 2nd day for that period.
You picked section 11 and you did not pick section 10 of the Penal Code Act.
My lord, I read it verbatim.
No, I mean section 10 of the Penal Code Act.
Yes, my lord, it's what I read.
You read section 11.
I read section 11.
You read section 10. Because section 11 arises out of section 10.
My lord, you advised we come here for submissions. I did not carry all the laws. It was not adjourned.
It is
That-
well. It is okay, Mr. Kumbuka. Let's proceed.
Yes, my lord. My lord, another factor to consider is sickle cell. Yes.
Okay. You're saying
The
that
unrevealed medical condition at that time.
so in conclusion, the evidence demonstrates that at the time of the offense, Christopher Okello Onyu, the accused person, was suffering from
That sickness I was spelled.
schizophrenia. But I asked you where you got that from because I don't have it as my evidence.
My lord, I got it in PF20 for that word for my first time.
Okay, let's proceed.
Therefore, I invite this court to come to a conclusion that significantly, Fatore was the one, he was impaired.
I think we have to have a position.
Much obliged.
Was he the one and he was impaired, or he was not the one and he was impaired?
My lord, I'm going to that evidence of participation.
We are concluding. Let's proceed.
I'm concluding on that fact I started with on section 11.
Okay, fine.
Much obliged.
We invite this court to come to a conclusion that
The fact that he was found with medication at the time of arrest is a sign he had a mental challenge. In case this court finds him guilty, is to find an innocent guilty of an innocent person. To find him guilty is to find
him guilty is
to find an innocent person guilty. This might be erroneous, dangerous to the legal profession, and worrying to the families in Uganda plus elsewhere that have people with such challenges.
Dangerous to the legal profession and
to the society at large, especially families who have people with mental challenges. My Lord, allow me go to a criminal doctrine of negligence. My Lord, at page 54, nobody was attending to the children out while playing. PW6 said on page 51, and page 60, that on that the whole school, or called Early Childhood Learning Center, has about 66 children and PW7. And on that day, there were 2 female human beings in the name of PW6 and 7 attending to these children.
there were others. There is somebody called Nora, to my recollection, and another one. So it is not true that there were only 2 people.
My
At
Lord,
least from the record.
according to my recollection, they said in total there were 4, but that day, at that time, there were 2.
No.
My Lord, I pray that I leave that to you.
Okay, fine.
Much obliged. My Lord, there was no security guard. And there was an exhibit we relied on in a police statement. Throughout the evidence, there was no visitor's book where they could write the identity of a visitor. My Lord, it is a big absurdity that on the first day of April 2026, Prosecution tried to play here evidence on video how that person visited. That evidence was unclear as to who was in the video. I brought it to the attention of court that day. My Lord, on the record, that on the second day, between 10 to noon, the very cameras that tried to show us that person who visited on first, they were off at the time of this offense was committed. No explanation was given to this court for those reasons.
Actually, the witness said that he established that there was a power shutdown.
My Lord, it should have been the controller of these cameras to come to court to clarify that. This person, the witness who testified about that, was not in control of these cameras. And that such patients, the painkillers alone they go through can lead to mental illness.
Killers, they go through the pain they go through. And
They go through as...
And the medication they take.
And the medication they take. My Lord, that is on page 147. And that is PW 12. My Lord, in Uganda, according to section 11, it's established that if a person is incapable of understanding their acts due to the disease of the mind at the time of the offense, cases involve strict psychiatric evaluation, often resulting into special verdicts of not guilty by reason of insanity. My Lord, this was alluded to in Uganda versus Kantinti Joel, criminal section number 87. Criminal section 87 of 2025.
2025? You have a copy?
Yes, my Lord.
Do you have a copy?
My Lord, I do not have a copy here.
We shall find it.
We shall find it on internet. I pray you find it on internet.
Okay, I will.
The court held that the prosecution proved the offense of aggravated defilement. The victim of the offense was 14 years. Sexual act by the accused. The accused was identified at the scene of crime. However, based on psychiatric evidence, the court was satisfied that the accused was mentally ill. And lacked criminal responsibility at the time of the act. Invoking section 49(1) of the TIA, the court entered a special finding of not guilt by reason of insanity. Pursuant to section 49(2), the accused was ordered into a custody as a criminal lunatic at Makshoni Bay Hospital. Pending direction from the Minister of Justice and Constitutional Affairs. By Honorable Justice, Lady Justice Sarah Langa Siu, your sister. My Lord, at page 11, PW 11, I mean, not page 11. At page 129, told the court that the symptoms of, I quote, I can't pronounce this word. Yes, my Lord, exactly that word. Delusions, hallucinations, laughing, were one of the indicators of mental illness.
Is that what he said? Mr. Kumbu.
At page 129, my Lord.
What did he say?
My Lord, he says, I quote, said, my Lord, symptoms include delusion, hallucination, abnormal posture, incoherent mood, and incoherent affect. Then he defined the meaning of affect.
Okay, it was hallucinations, abnormal posturing, then mood what?
Incoherent mood.
Okay.
And he actually quoted again the same page that a person may report that they are hungry, but when they are laughing.
They are angry, not hungry.
Hungry.
Ah, hungry.
My Lord, it is H.
I think the person who transcribed and recorded was not it.
And my Lord, in this court, this particular chosen person has been laughing frequently. My Lord, I invite you to look at PF 24, and I want to read verbatim to this honorable court.
The number? Is it 7? PX7?
And I pray you will quote PF 24. We shall be there
Okay.
at any time. It's what I'm reading from.
Okay.
Much obliged. These are his findings. The findings above suggest of a mental condition.
Mr. Kumbuga, please. I thought we agreed let's be professional enough. When you read that PF 24, he made his observations arising from his examination, and then he noted what he told him, and then he's talking about the above findings.
Yes, my Lord, that's why I'm reading his findings. This is not my word.
Not his findings, the findings of that history.
Okay, my Lord, it's all right. You can write like that. But allow me.
Please read.
Allow me read, my Lord.
Please, go ahead.
The findings of the above are a suggestive of a mental condition with psychotic episodes. Psychotic episodes. This is his recommendation. Further, mental assessment is necessary since no medical document were available to me, and he was the only source of information. My Lord, as I started the submission, that prosecution must prove its case beyond reasonable doubt. This being the exhibit of prosecution, and they chose to ignore further inquiries about the same. I pray that this court holds that inquiries were complete as to the mental illness.
Sorry, they chose to do what?
To ignore the recommendation of their own witness. I pray that this was intentional. And that if court holds otherwise, shall occasion gross miscarriage of justice. My Lord, the consequences of failure to rebut mental illness. Once evidence of unsoundness of mind arises, is detrimental to the prosecution case. No cogent psychiatric evidence was tendered to negate the mental illness of the accused before you throughout the prosecution evidence. Whereas PW 15 on page 223 considered to the fact that he was in possession of the information that for 8 to 9 months the accused was in Utavika Hospital receiving treatment.
He's referring to the investigating officer. I think that is Esther, right, James?
Yes, my lord.
PW 15.
At page 223 of the court report. On page 228,
Finish the sentence.
my lord, where did I get
You
it?
did not finish. You say the fact that he was in possession of the information that for 8 to 9 months the accused was in Utarika Hospital.
On mental treatment. Prosecution ignored that. He went ahead to say, at the time of arrest on page 228, the accused had painkillers like diclofenac. In conclusion, therefore, my lord, the evidence demonstrates that at the time of commission of offense, Christopher Okello Onyum was suffering from that word I can't pronounce, SHR.
Diagnose him?
Huh?
Are you going to diagnose the condition?
No, my lord, I'm pronouncing for you. It's just my final remarks.
No, schizophrenia.
Yes, my
I'm
lord.
wondering where you're getting that that's what you were suffering from at that time, because it didn't come out in any evidence.
It didn't, but these are submissions. It's
But
my
you-
personal submission.
Where do you find it? Because this is a,
My lord.
this is a medical condition, and
Okay, my lord, unrevealed by prosecution evidence.
no, you don't do that because it is not right. If you thought the disclosures were given to you and you had no adequate time, you should have informed the court, and I would have given you that time.
My lord, I consider that wisdom, but as I was cross-examining, witnesses were conceding to that fact that, and they were reading to this honorable court that I made my report on the 17th day, April 2026.
That is very true, but at the time they came to testify, the disclosure was made to you, and you never at any one time informed the court that you had limited time to be familiar with the reports, which time I would have given to you. So when you raise it now, I am again saying it is irregular.
My lord, I pray that you allow me quote this. At submission, any offending of the law can be brought to the attention of court.
But now,
But my lord, thank you
Counsel,
for the
were-
overruling me.
you- and of course, this is of course without any offense. Okay. Yeah, because you see, if that's the reason you are there, if you had any issues with either late disclosure of some of the evidence, you should have brought it to the attention of the court, but you did not.
Much obliged, my lord. PW 17, my lord. Assistant Superintendent of Police Haleriman Barnabas. My lord, he said that the bodies were tampered with of the late by the time an examination was carried out.
He didn't see
The
the
scene
bodies.
of crime.
Mr. Tkumbuga,
Yes, my
this
lord.
is a DNA analyst.
Yes, my lord.
He did not see the bodies. He saw samples from the bodies, the swabs from the bodies, but not the bodies themselves.
Much obliged, my lord. My lord, let me read to you this verbatim,
Okay.
and then you advise.
Okay.
The suspect's shirt shown that there was only the DNA, yet we were told he was subdued and arrested. By the time, by people, by the people. How come that the DNA was not found on his shirt? That's the question, my lord, this honorable court should answer.
No, I don't answer questions. I want you to read for me that and which witness said that.
My lord, it is PW 17. On page 267. My lord, this is what he said. Let me read it verbatim. And my lord, I don't intend to put there my opinion.
It is okay. You can read it.
If the specimen is not donated, still I can easily know that the specimen has a mixture, but on analysis, the person with the mixture is not among the people who has been donated. That's the statement. My Lord, I pray that you will find out on the record for your analysis of the evidence.
That's fine.
Much obliged. My Lord, the last PW18, Angulo Kenneth.
Prosecution, is it L, is it R? Angulo.
It is L, my lord.
L. Double L.
My Lord, he said his investigations depended on court order. I asked him whether in his report there is not so motion. He said no. The affidavit was not deponed. The order lacked a court seal. The signature on the order is the same as the signature on the commissioning officer. So in case, yes, my
The
lord,
signature of the
Order.
judicial officer
the signature of the on the court order, the alleged court order
of the judicial officer.
of the alleged judicial officer
Okay.
is the same as the signature on the affidavit. Commissioning. My Lord, I trust the body that recruits the judicial officers in Uganda. I don't think in Uganda there is a judicial office who can come up with an order at the same time with commissions. And if it's so, in case this judicial officer is identified, I think should be forwarded to Judicial Service Commission. But there is no court seal to identify the court that participated in this. Therefore, where did these documents originate from that led to this kind of inquiry? This particular evidence was brought to the attention of court. Prosecution ignored to bring any witness to clarify on this. Therefore, in the absence of the officer from court, I invite this court to hold that this does not amount to a court order. Therefore, whatever is started on falsehood, the end must be false. I I pray that while coming up with this judgment, court this evidence. However, I will go ahead and continue analyzing whether it was relevant or not. My Lord, in cross-examination, this particular investigator was asked whether his name is on the record. He said it is not there.
On the report.
On the report. Loophole will live to haunt the whole nation. My Lord, it's alleged that it's a security guard and another person that subdued this person and detained him. With all the experiences of the police officers who came here and the land state attorneys who advised, they chose not to bring anybody. The question is, who handed over the alleged person to police? Was he picked on the street? Is he the one? My Lord, that will be answered by this honorable court. My Lord, PW7 was baptized to be a police witness. Odong, Annette. Her statement was not signed by any police officer. She denied the statement being self-recorded. My Lord, prosecution tried to give explanation for that. It was overruled. No police officer was brought to this court to verify whether she's a police witness, but probably it was in omission. The court shall live to guess. there was no police guard or security guard, I mean, my lord. However, my lord, what surprises this court that PW6 said there was. PW7 said there was in her examination in chief. Upon cross-examination, she said there was no, and her statement was tendered in. PW7 is the one who said that she called PW6 to go and attend to the children when they were being attacked. She shouted, in fact, she said she shouted at PW6. PW6 was very silent on that statement. She struggled alone. My lord, with all the negligence, contradictions, and inconsistencies mentioned above, impact the overall credibility of the witnesses and integrity of the evidence. And I invite this honorable court to rule that in the favor of the accused person.
I take it that you are also contesting the participation of the accused person?
My lord,
Because I'm failing to get your line of argument. You seem to say the accused person acted out of a mental condition, and now you seem to suggest that actually he's not the one. So you're almost leaving court in confusion to know your line of defense and argument.
my lord, I trust your experience that during your remarks you will come up with a very good judgment.
Proceed.
Much obliged, my lord. My lord, allow me from PW 13 go witness per witness. PW 13, my lord. AIP, I think, Odong Emmanuel. The camera is the camera.
The CCTV analyst.
Yes, my lord. This kind of evidence, it was very dark as to identify who was in this video. Motorcycle number plate was not seen. The cameras were off on that day. At the circle.
At the renewal circle.
Yes. At that particular time, they came on at noon. At noon, 52, 22 hours. Still, the statement of anybody from the manager of this CCTV camera is lacking on record. PW14, Detective Mutaka Jimmy. He told the court that all exhibits were submitted by Inspector Semanda, the IO. My Lord Semanda was not brought to court. So who was the IO? These were real exhibits brought to court. Semanda didn't come to court to identify any. So it touches their credibility and integrity to meet the standard of being tendered in court.
But I thought we tendered them already.
Much obliged, it is true. But my Lord, this is my submission. My Lord, the same person said that there were no fingerprints lifted. At page 228, he said, I know the consequences of failure to lift the fingerprints, but I didn't do so. This offends the principle of proving a case beyond reasonable doubt. My Lord, PW16, Detective James, PW15. He said he supervised the inquiries. But he was not familiar with the whole police file. My Lord, he quoted to this court that the accused person knew the consequences of his acts, and he told him so. When he was asked whether, as police officer, he knows the consequences or the importance of such a statement, he said yes, that it is very important. When he was asked to point to us in the whole police file where this statement is, he confessed it is not there. My Lord, if at all he knew that this statement is very important and it's the backbone of this case, and all the witnesses plus police experts failed to write it on record, if court holds otherwise, it will lead to gross miscarriage of justice. I invite this court to disregard this statement as being misleading. My Lord, at page 245 of PW 16, Mpamizo Agre, plus another officer, my Lord, they confirmed to this court that as in this case was going on by 13th April 2026, inquiries were still going on. My Lord, this kind of evidence touches Article 28(1), the doctrine of fair hearing, and also preparing for defense.
Counsel, you never at any one time raised an issue of lack of preparation?
My
So
Lord,
when you raise it now at this time, I find it irregular and almost unprofessional.
my Lord, allow me to use Article 28(1), fair hearing, which is an inalienable right. My Lord, as inquiries continue when court is continuing, it offends that article.
So you'd never at any one time raised that when we were proceeding? When they brought that and disclosed it to you, you never brought it to the attention of the court? So I find it irregular that you're raising it now.
My Lord, let me allow me give you this explanation. My Lord, it's not the defense to prepare the prosecution. As defense, I can look at evidence and do not cross-examine on it because I know it is irregular. In my submissions, I put it there. You learn to know the consequences of failure to write your name on a report, because he is a professional police officer. And he was asked whether his national ID has his name. He alluded, he said it is true, his name is there. So he knows the consequences. My Lord, this person was asked whether the alleged police hotline 112 and 99 were called on, and whether he has any writing or voice email to show that that voice is connected, accused in court. He said he has no writing or voice email. And he alluded the fact that he has left it for court for guesswork. My Lord, on issue of Google search, he alluded the fact that doing a search on Google does not offend any law in Uganda. He was asked whether he knows his investigating colleagues went to find out whether this person, after Googling, went to the particular schools, particular institutions. He said he doesn't know. So this evidence is on court record idle. In case they wanted to rely on it, it offends the principle of proving a case beyond reasonable doubt. Meaning his search on Google never offended any Ugandan. My Lord, the concluding remarks on this kind of poor investigations is stated herein. Poor investigations are not mere administrative errors, but systematic breakdowns that cause profound harm to the victims.